I did explain
And
it
that's
to
the first
her.
time he's contacted me, Your Honor,
Ms.
since I came
Brink,
to
stop. Ms. Brink, you don't get to interrupt when somebody else is talking.
What I'm trying to report to you is that he's being a bad attorney.
Mute her. This is the State of Michigan versus Chelsea Brink, file 25-44051-FY. And we also have Chelsea Brink, State of Michigan versus Chelsea Brink, file 25-44174-FY. Mr. Brown is back. Let's see, we have a response from the Center for Forensic Psychiatry in file 44174, but I believe this is as to both files. Is that correct, Mr. Brown?
I believe so, Your Honor. One is a probation violation.
All right, that is true. I see that now. Mr. Brown, I've received a copy of the report from the Center for Forensic Psychiatry dated January the 29th of 2026. Have you received a copy of that as well?
I have, Your Honor, and I did attempt to go over that with Ms. Brink a couple days ago.
All right. Mr. Fortier, have you received a copy as well?
I have.
Mr. Brown has to. Ms. Brink, I'm sorry, I didn't hear what you said.
I said Larry ignored me for 3 weeks.
Has he tried to get a hold of you and talk to you about this report from the Forensic Psychiatry Center?
I tried to get a hold of him 4 times, and 3 times before that via email. And this is really all about just like some stupid shit that got blown way out of proportion. I've been in jail 90 days on a 30-day charge, Your Honor.
Well, the report from this forensic center, and actually it's not a 30-day charge. You're on a assault of a police officer charge and a habitual offender.
No, I'm on an RNO and a trespassing, and the original charge is a 30-day charge. And this is all about me pop tired, to be perfectly honest with you.
Okay, Ms. Brink, are you aware of what the forensic center recommends? That they find you not competent now, but that they think
well,
that you
I'd like to contest that because I am competent. And I don't feel like I had a fair evaluation, to be perfectly honest with you, and that Larry's not doing his job.
Ms. Brink, the question was, are you aware of what the forensic center said?
No, I'm not. He didn't say anything. Neither did she. She just kept asking me history questions, and so I answered the questions, and when I realized she wasn't doing any serious evaluations as far as whether or not I'm competent, then I hung up, because that's bullshit, just asking me about my history. When I got to gun talk, I was like, no, I'm not doing this with you, because that's bullshit.
All right. And so they've sent me a document that goes through all of that and then goes through their analysis, their behavioral observations, their consultation with jail staff, their review of your records, and their assessment.
They didn't do any of that, Your Honor.
Mr. Brown, was she able to receive a copy of this?
I don't believe she received a copy, Your Honor. I did speak with her. I called the jail back on the 10th, 2 days ago. I did speak with her for a while. I did explain
and that's
it to her.
the first time he's contacted me, Your Honor.
Ms. Brink, stop. Ms. Brink, you don't get to interrupt when somebody else is talking.
What I'm trying to report to you is that he's being a bad attorney.
Mute her. You'll be given an opportunity to talk when it's your turn, Ms. Brink, but you do not get to interrupt anybody else. Mr. Brown, go ahead, please.
Thank you, Your Honor. Again, back on the 10th, 2 days ago, I did contact the jail. I spoke with Ms. Brink. I did explain this to her. She is basically saying to the court right now what she said to me about not wanting to accept the findings. There were some comments made that prompted an officer to take the phone back, and that kind of ended the conversation. I did have a subsequent conversation with Mr. Fortier very briefly after that matter regarding the report as well.
All right,
Guys, buckle up because this courtroom is already off to a chaotic start. From the very first seconds, voices overlap as the judge struggles to maintain control while the defendant repeatedly interrupts proceedings. What should be a structured legal hearing quickly turns tense as multiple case files and forensic reports are introduced. The state is clearly building a formal record, but the real friction begins when communication issues and frustration surface. The defendant pushes back emotionally, claiming she's being ignored and mistreated, while attorneys try to stay focused on the psychiatric evaluation. By the end of this segment, the tone is already set, authority versus resistance, and neither side is backing down easily.
So she is aware
All right.
of the findings. She obviously does not agree.
All right. Can we unmute Ms. Brink now, please? Now, do you have something that you wish to say, Ms. Brink?
I have lots to say, but not to you guys.
All right. Mr. Brown and Mr. Fortier, as to admission of the forensic
Except
center.
that I do want to contest the findings, like I've already stated.
Thank you. I'll give you an opportunity to do that in just a minute, Ms. Brink. Mr. Brown and Mr. Fortier, as to the admission of the Center for Forensic Psychiatry's report. Any objection to that being considered by the court?
No, Your Honor, no objection.
No, Your Honor.
All right. Ms. Brink, please tell me what your objection is to this report and why you think that you would be competent to stand trial.
Because I am competent, number one. I have 2 children. That makes me automatically competent if I can keep track of my children and know that they're happy, healthy, and safe, and know what their names are and their age and where they go to school and et cetera, et cetera, et cetera, which I do and can. That makes me automatically competent, for 1. For 2, I know my history. For 3, I know exactly what this is about. And I've ignored my husband, or husband-to-be, whatever you want to call him, for a long time, and he's pissed off.
Ms. Brink, do you know what the legal definition of competence is?
Being capable of talking, to be perfectly honest. That's the definition of competence. Being capable of talking, which I am.
Well, it's a little more than that. Part of it is...
And it doesn't matter. I get a new hearing and a new evaluation because I'm contesting it.
That's not true.
That is true. That's the process.
All right. Do you believe that you are capable of rationally discussing the facts of your case with your attorney?
Not this attorney, but a different attorney, yes. I'd like to request that my husband call his attorney.
This is the only attorney that you've got.
Well, he's not doing his job properly, never has, and this is the 3rd competency evaluation I've done. All 3 I've passed, and you're lying.
All right. Anything else that you want to tell me, Ms. Brink?
I can't think of anything right now, but that doesn't mean that there's not anything else I want to tell you.
Thank you. All right. This court finds, based on the evaluation done at the Center for Forensic Psychiatry, that Ms. Brink is incompetent at present time because she's not able to rationally discuss the facts of her case with her attorney or critically evaluate decisions. Ms. Brink, this is my turn to talk, not yours. That she's not meaningfully able to engage with her attorney or maintain appropriate courtroom demeanor as indicated by her talking over others and not being appropriate in court today. It's also the opinion of the evaluator, and the court adopts that opinion, that there is a substantial probability that she can be restored to competency if she takes their medication and avails herself of other appropriate treatment programs. And that can be accomplished within the statutory time period for regaining competency. So the court will enter an order.
All right, guys, this is where things start escalating fast as the forensic psychiatry report becomes the center of conflict. The defendant outright rejects the competency findings, insisting she was not properly evaluated and arguing she is fully capable of understanding her situation. The courtroom atmosphere becomes increasingly unstable as she interrupts repeatedly, forcing the judge to step in more aggressively. At one point, control is so strained that she is ordered to stop speaking and is muted to restore order. Despite legal professionals trying to explain the process calmly, her frustration continues to boil over. This segment highlights a critical breakdown in courtroom decorum, where legal procedure clashes directly with emotional resistance and personal denial.
The defendant is incompetent to stand trial, but is restorable, and that there is a substantial probability that she, if provided a proper course of treatment, will attain competence to stand trial within the time limit established by law. MDHHS is appointed as the medical supervisor of that treatment. Court orders the disclosure of necessary information to facilitate that treatment, and as a condition of release, the defendant will comply with all court-ordered treatment, and the court signs that order at this time.
Judge, just for clarification purposes, the evaluation and the opinion stated that in a hospital setting is where she could attain competence. So I guess my question is, or my request would be, that she remain in the custody of the county jail until a bed is made available at the forensic center, at which point she can be transported down there and medically supervised by the forensic center staff to be in that hospital setting. Specifically, kind of looking at MCL 330.2032 sub 3. That one is: the court may commit the defendant to the custody of the Department of Mental Health or to the custody of any other inpatient mental health facility if it agrees, only if that commitment is necessary for the effective administration of the course of treatment. Given the opinion by the evaluator in the evaluation, I would ask that the court find that be the case, and that she, again, remain in the custody of the county jail until a bed becomes available.
Mr. Brown, your thoughts?
Your Honor, she does have a bond. I would have no objection to that, and do believe that she can be restorable with proper treatment.
All right, I've written on the finding and order of competency that the defendant is to remain in the jail until released to the Center for Forensic Psychiatry / Community Mental Health for inpatient treatment. And I'll do that on an amended bond form as well. That's all for today, then. Thank you very much. And that will apply to both cases, pending cases. Make a note on that one. Okay, can't do.
Is that all, Your Honor?
I believe so, as to your facility. Thank you very much.
All right, guys, now we move into the decisive phase where the court begins to take full control of the situation. The forensic report is formally admitted without objection, despite the defendant's strong disagreement with its conclusions. She attempts to defend herself by arguing she is competent based on personal life experience, but the judge clearly shifts focus to legal standards rather than personal belief. As questioning continues, it becomes evident the court is not persuaded by her reasoning. Finally, the ruling is delivered: she is found incompetent to stand trial, but restorable with treatment. The judge orders psychiatric care and continued custody until placement is available. This final segment closes the loop with a firm legal resolution, turning emotional dispute into formal judicial outcome.